of today's webinar is to look at stress testing your estate plan. And after the leading up to this particular webinar, we've had several very interesting conversations and aspects of estate planning that I had never considered or had considered, but just put on the back of my mind, not to worry about, has been brought up, and they have introduced a very interesting product. And I'm sure that everybody joining us today will after this webinar be feeling very much like I'm probably feeling now, which has got an, oh my goodness, best I get sorted. But before we get going and I introduced our panelists, I just quickly want to run through a few things. This is an open forum for discussion. So I have received some of the questions prior to the event. So thank you very much. We will do our best to address those questions. But if you look at the bottom of your panel, you will see that there is a box that says chat. If you click on the chat box and make sure that you select the option of everyone, you will be able to post your questions inside that little chat box. On screen with us, we have our Carrick Consult experts, but behind the scenes, we also have our keyboard warriors who are all there to answer any questions or to assist you with any additional information that perhaps is not covered. So I really hope that you enjoy the next 45 minutes, find it interesting, valuable, and enlightening. And before one more thing, I mustn't forget, during the course of the webinar, we'll be asking 4 poll questions. Tandu will release one of those poll questions now so that you can see what it looks like. What you do, the poll will come up onto your screen. You can just answer the poll, and then once you've finished answering, just click on the red toggle and it will remove it from your line of sight. It's quite nice for us to know a little bit more about you so that we can position our webinars so that they're more relevant and that the content is interesting to you. So without any further ado, let me introduce Anthony from Carrick Consult. Anthony, the floor is all yours.
Thanks, Louise. Really, really great being with you today, as well as all your viewers. Hi, everyone, and thanks for joining to discuss the subject of estate planning, which is unfortunately an often highly neglected area of financial planning. I think it's pretty safe to say that most of us have experienced just how traumatic, confusing, stressful, and emotional it can be to wind up in a estate, often taking years and years. And that is when some level of estate planning has actually been done. The unfortunate reality, and one that we face with on a daily basis, is that a lot of people have done no planning at all and don't even have a will. So you can just imagine the additional complexity that is involved. My name is Anthony Palmer. I'm the Group Commercial Director for Carrick Wealth, which is an independent financial planning and wealth management business. Our offices are across South Africa, and we specialize in first structuring our clients' assets from a tax, asset protection, and succession planning perspective, and then we look at appropriate underlying investments. We are both onshore and offshore focused, which is a very necessary skill when assisting clients with their local and cross-border estate planning. We're joined today by Louis Venter, founder of our fiduciary business called Carrick Consult. Louis is an admitted attorney and has been in the estate planning industry his entire working life, having set up and run the fiduciary businesses for some of the largest wealth managers, trust companies, and banking groups in South Africa. We all need to be passionate about something, and Louis' passion sits firmly in how to ensure wealth is passed on as efficiently as possible to our loved ones when our time eventually comes. Louis has pretty much seen it all and speaks to us today from a wealth of hands-on experience. He will enlighten us on what estate planning should be and drill down into a specific product that he has developed. I definitely don't want to steal his thunder, so we'll leave the explanation up to Louis. But I can confidently say that every single client who engaged with us had the same positive reaction regarding the value that was added to their financial planning. Louis, I think this is a great time to hand over to you.
Thank you very much, and welcome everybody to this discussion. I hope you find it insightful. absolute pleasure and privilege to be speaking to you. There will be time for some questions and answers afterwards. But I think one of the big issues that I've experienced spending quite a bit of time in the estate planning space is I think we sometimes do fall into a simplicity trap. And what do I mean by that? I don't have any problem with questions being simple, and I'm sure some of you and most of you have got a few questions on your mind. It's like going to the doctor and saying, but I've got a headache, how do I solve it? It's a fairly straightforward, easy question. And it might also be that the answer to that question would sound simple, but what one shouldn't do is the process of going from the question to the answer. One shouldn't skip complexity, because in reality, there's lots of complexities around estate planning. And my invitation to you today is to be a little bit braver. And if you're not brave enough, go and find yourself an advisor that can guide you through the complexity of the estate planning Pandora's box. So sit back and join me on my journey as we go through this Pandora's box of succession planning together. You will find that it is absolutely worth pursuing finding the simplicity at the other side of complexity. But that is what we as advisors do. You would expect the same from all professionals that you go and see. So let's start with a simple question then that I'm going to try to answer today. So how can I transfer the wealth that I've accumulated to my heirs? And I want to emphasize the word successfully. So in the end, everybody needs to transfer their assets. We've got no choice. Unfortunately, our lives are finite. So the succession paradigm needs to be solved. The only question is, were you involved in solving that paradigm, or do you leave it up to chance? My experience is in 80–90% of cases in South Africa, it is being left up to chance, and I think there's something that we can do about it. That is why we developed the MyLnD program. And once I go through these slides, you will quickly understand exactly where that fits. So the lazy answer to that question is, well, simply just draft the will. I say, okay, so in order to draft the will, and in order for you to know that it is simple, surely you should look at the data first. It is very difficult to understand how you can do estate planning without understanding the data points. And there's lots of them. I'll go through most of them to give you some idea what you need to consider. Then very important, you should understand the law. And if you don't understand the law, then your advisor should understand the law. That is our role. Our role is not to guess law. Our role is to know the law. And the problem that I find in the industry these days is that many people advise from a secondary understanding of the law. It's advising from what other people said. Very few go back to the primary source of knowledge and advise from there. That typically is in the lawyer's training to do that, which I think is very important. And then thirdly, maths is something that you do. You don't guess maths. And you will see that doing the maths sometimes gives you different results. It is absolutely worth doing the maths and seeing what you had in mind, if that will actually happen. And that is not difficult to do. It's one of these things that really is not difficult, but it's got a great value for you if you do go through the process. So let's look at estate planning in general. Estate planning has got two contexts. The first is a family context. So all wealth is accumulated within the context of a family. That is how we are made up. We are not loners. We are a tribe animal. And within this, we live within families. The wealth is generated within families, and the wealth is there to serve the families and to serve the generations. But family relationships are extremely varied and complex, and I am absolutely certain that everybody around the table will agree with that. There's no two families that is alike. To give you an example, about 70 or 80% of family feuds that I've encountered through many years has been because of perceptions of fairness. Now, if you go into perceptions of fairness, you can understand how complex things get within very simple family groups. Mom and dad still together, 3 kids, etc. There's 5 relationships there. And if it's only me and my wife, that would be it's complex, but it's not that complex. But let's say it's complex to the degree of 1. If you add your children, and there's 3 of them, the relationship complexity goes to the to the power of 3. It's not times 3, it's to the power of 3. And that's just within your family relationships. Within that family as well, the relationship between the 2 primary spouses, that in itself is complex, not just emotionally, but also with regards to how the marital assets are kept, what is the marital regime that applies. If you just think, for instance, of in-community of property, if I tell you, if you are married in community of property, what do you own? Well, you own an undivided half share of the communal estate. That is the legal answer, right? Now, just in that sentence, there's massive complexity. So you might think you own half the house if you're married in community of property. You don't. You own half of an undivided share of communal estate. So now you draft the will and say, well, I'm quickly going to draft my will and give my half share in that house to John. Well, you can't, because you don't own half of the house. Same with accrual system. Accrual system is complex. To do the accrual calculation is very important to know what you can bequeath. And that is just the relationship between the primary role players in this estate planning. Let's go 1 generation up and say, all right, so there's a generation preceding you, because estate planning and succession planning is about managing the flow of wealth from 1 generation to the next. So if we go 1 generation up, if something happens to you, what about your parents? Are you currently looking after your parents? How should we look after your parents? Your children can't look after your parents. It doesn't work like that. It is not natural. You must provide for that. The second question is there wealth coming from your parents to you? You might have a fantastic estate plan and think your life is very simple. But then if there's assets that's bequeathed into your generation, what planning has been made? Is there a correlation between the planning of the preceding generation and yours? Then your children might be living in different places. Some might do very well, some might not. Some might be living in South Africa, some might be living in the UK, Australia, America. We are finding that South Africans are exporting 2 things. The one is their wealth and the other is their children. And I can't count myself as one of them. My son is studying in the UK. So what complexity does that bring? Where will my grandchildren be one day? These are realities, and it's practical questions that makes what seems like a very simple question a very difficult answer. The wealth itself, if you think of your wealth and the wealth that you've got and you've accumulated, if you bring your balance sheet to me, I immediately split the balance sheet into 4 categories, because there's a difference between the assets that you hold in trust, the assets that you hold in your personal capacity, the assets that you hold in companies, and in pension and life products. There's a huge difference between those 4 silos. And from a legal point of view, you need to be able to address the succession plan across all 4. So if your simple answer was, well, estate planning is the doing of a will, and you have got assets in all 4 of these silos, unfortunately, you get 25% of mark for the estate planning. And if you ask an advisor to do it, even worse. The advisor shouldn't be getting 25% for the estate planning that's being done. The point here is there's a fair amount of complexity. on the one side, there's the emotional complexity of the family, which I think is very relevant in succession planning. And then there's the complexity of the wealth context. But let's just answer the question from the emotional point of view and saying, I want to transfer my wealth to my heirs successfully. What does successfully mean? Right? Does it mean that it actually reaches the next generation? Or is there something else at play? What we've seen, and this is some guidance that we can provide, is through trying to understand this Pandora's box of family relationships and how do we successfully transfer wealth from one generation to the next, we can give you some guidance. There's basically 5 laws that determine how successful will wealth transfer from one generation to the next. And I'm quickly going to use a symbol to illustrate this for us in a relay race. And let's say, for instance, in this relay, it's one generation running to the next. And the wealth that we've got is the baton that's being transferred. To run this race successfully, you need to understand and you need to know that you are mortal, right? Which means that you will only be the carrier of this baton for a certain point in time. Therein is a lot of emotions, and it's often difficult to do that. People that's got a custodian mindset, from our experience, is better at succession planning than those that's got an ownership mindset. But then the next runner needs to look back over his shoulder to the runner coming to them, which means there's communication between the 2 generations. The biggest factor in successfully transferring assets from one generation to the next is the quality of the conversations that is had between generations. The better the communication, the better the succession planning. The whole thing of one generation building wealth, the next one consuming it, and the third one starting all over lies in this simple factor. The next generation needs to understand where wealth is coming from. There needs to be a platform of communication. And this is where the advisor could be very, very handy, because the advisor would be able to guide these conversations, which I think is absolutely critical. There must be a mutual willingness. So the willingness is in the open hand to take the baton. So usually that second runner, that hand is open and they're willing and able to accept that baton. That is absolutely critical. We see that practically, for instance, in the transfer of businesses. If your son or your daughter don't want to take over the business, or they don't want to farm, that is a guaranteed failed succession if your succession planning for your business is that needs to happen. If there isn't a willingness, etc., it's better to sell the asset, for instance, than to transfer it. Now, you can see the business asset itself is something that is in your estate, or it's something that needs to be dealt with. But the plans that you make needs to be done beforehand. Usually the one runner's got a bit of a head start. So the one runner starts running before the other comes in. That we see with trust, for instance. We bring in as standard, we bring in our children, or clients' children on trust at the age of 30, so that there is a smoother transfer of wealth, that you don't have this lotto effect of inheritances. We know that lotto winners lose their wealth within 5 years of getting it. We don't want that for succession planning, but it more often than not happens. Don't grow up thinking, letting your children thinking you're a pauper if you're not. Okay, so they need to understand wealth, and they need to understand where it's coming from for them to successfully carry it to the next generation. And then the last one on this is repeat the process. So if you are the second runner, you run towards the third generation, the third runner. Don't try to resolve issues in the past in working with the next generation. That is also an area where a succession failed. If possible, and I know it's easier said than done, but make peace with the past and work towards the next generation. That I can tell you is more or less the rules of running the successful relay. Very easy for me to sit here and say that. I know, very, very difficult to do in practice. Now, where we get involved as advisor is when we break up this pattern into these 4 silos. And I'm going to repeat, the 4 silos is your trust assets. Trust assets are dealt with in terms of a trust deed. It's looked after by trustees. It needs to adhere to the law of trusts and lots of complexities with regards to trusts. The one benefit of a trust is that nobody owns a trust. So anything in the trust is there. By its nature, it's multi-generational because there is no personal ownership on that. Your personal assets are those that you own personally. It is subject to your marital regime, which again is becoming a very, very complex topic. There is currently a legislative process going on in South Africa to change our whole marital regime simply because it's become so much more complex than it was in 1984 when the legislation was written. And I'm sure I don't have to try to convince anybody around this room that our idea of marriage, marital relationships, universal relationships, etc., is way, way, way different than it was in 1984. But still, we default to almost a paternalistic view of marriage that we had in 1984. It's just where the legislation comes from. The company assets, if you own something in a company, you can't deal with it in a will. So if I own my property in a company, I can't in my will say, I hereby bequeath my property to my son John, because I don't own the property. I own the shares in the company. I can deal with the shares. So it is extremely important to understand these silos and understand where they're coming from. And then lastly is the pension and life assets. So these are the assets that, for instance, is in my life cover, my annuity funds, my pension funds, etc. It's also one of the assets that needs to be transferred, but can also not be dealt with in your will. So the simple answer to say that my estate planning lies in my will is definitely false, because most people will have assets in more than one of these silos. All right. So even if it's just I've got my assets and life cover, you are triggering 2 of these silos. To make it slightly more difficult, all right, so this is easy enough if everything is in South Africa. If these assets are abroad, each jurisdiction where your assets reside means that practically succession planning needs to be done and probate needs to be done unless it is correctly structured. So when you're structuring your investments, etc., you have to have your estate planning in mind in doing that. The MyLnD program, if you look at the silo 2, the personal assets, this is the attempt for us to simplify silo 2. Most of us, a liquidation distribution account, that's where the MyLnD comes from. LND stands for liquidation and distribution account. A liquidation distribution account is done after your death by your executor to give an indication what your assets, who's your creditors, how are they paid, and then who's your heirs and where should the wealth go to. So in most instances, this is done after your death, etc. But what that means is by the time we go into the detail of liquidation distribution account, it is too late to make any changes because the client has passed away. 90% of all delays in deceased estates is preventable. 90%. And this has got nothing to do with the Master of the High Court and the inefficiencies that's in the High Court. That perhaps accounts for a delay of 30 days in the estate administration process. Most of the time is spent in estate administration processes in finding the assets. This stage of the administration of estate process, from getting the letter of executorship up to the filing of the first liquidation distribution account, is spent finding stuff, paying debt, figuring out whether there is liquidity. If there isn't liquidity, trying to remediate that. If the plan that you had, if the simple will that was drafted for you or that you had drafted yourself, if that doesn't work, it means that it is spent trying to manage the conflict that then arises because of the bad planning. Now, this is preventable. And what we've done with the MyLnD program is we've brought that forward. There's absolutely no reason why I cannot draft a liquidation distribution account whilst you're alive. What it does is it forces everybody into the discipline of the detail. Everybody is forced to go into minutiae that I know delays estates. And it might be the type of asset you hold. It might be where you hold it. It might be who's the beneficiary of your life cover. Where is the liquidity? How much liquidity do we need? Is the life cover that you've taken out, is it appropriate or not? Is it appropriately structured? Does the legacies that you describe in your will, does it work? Where's the money coming from? What assets needs to be sold? So there's a lot of practical questions that we are in a better position to ask whilst the client is alive, because there's nothing we can do when the client has passed away. Most of the issues that we pick up, and we pick up a lot of issues by stress testing the estate planning, and it's simply taking the will, transposing it onto the assets and seeing, does the plan work? If the plan works, great. There's lots of value in knowing that the plan works as well. It gives peace of mind to know that that which you thought is going to happen will actually happen because it's been tested. If it doesn't work, we've got time to remediate, and this is the point, is we can remediate so that you don't have the complexities in the deceased estate process. The value of doing that lies in the time it takes to do the estate. You cannot get closure on the passing of a loved one if the estate isn't finalized. You get calls all the time, there's questions all the time, etc. It is a lingering thing. And there's no reason for that. There's absolutely no reason there. Bar for litigation between family members and bar for totally unforeseen circumstances, an estate should be wrapped up between 6 and 8 months. With the MyLnD, what happens is, because we've done the liquidation distribution account beforehand, we've got the data in the right way. We've tested the planning, we've got the data in detail, which means by the time that you pass away, within the first 30 days, we are in a position that we can actually lodge the liquidation distribution account. That which takes 6 to 8 months, we basically have done beforehand, which means the rest is just the normal processes that is legislated. And those processes, the legislated processes of administering a estate, right, means that the estate should be administered between 5 and 6 months. There is no reason it should take longer than that, even taking the inefficiencies that's currently at the master's office. So the program is designed at making sure, and the way we go about it is we make sure that we capture all the detail, we capture it in the right silos, we can give you a much clearer answer as to what is going to happen. You know that your planning has been tested, you know that that which you had in mind actually works. We know how we're going to get assets to the next generation, whether they're in South Africa or abroad. We get time to make the planning, and then the end result is that you've got a family that finds closure quickly. Your estate is wrapped up safely, efficiently, and quickly, and the rest of the relay can then go from there. So just to wrap up, before we get into the questions and answers, Louise, quality conversations, I think is critical. Please invest in those. And if you find that you do not have quality conversations with your advisors, please go and seek out an advisory relationship where you've got quality conversations. It is critical. All right. Testing the outcome of your current planning just makes absolute sense. We see that every single day. We live that experience. Gives us the opportunity to identify problems, find solutions, transfer wealth successfully. All right, and I know we only do the asset side. The quality conversations means that we've got a quality area to which the assets go. That is your responsibility. And then in the end, we've got a very efficient process. So I would like to invite you to embrace your complexity. It's what life is about. Life is complex, but it's what makes life fun. We are here to assist you in the process, and I think you will get a huge amount of value of embracing this new way and new approach to estate planning.
Thank you very much, Louis. That's great. So I thank you very much for the presentation and for the information. We have a number of questions from the audience, but just before we get onto those, we took an earlier poll at the beginning of this event to find out why people were attending the event, what they found, what was their primary driver. And I think for most people that are here today, it is that they have a plan. There was a few people who don't have a plan yet. They're working on it, but there are a number that have a plan and they would like to stress test it. So you've explained sort of an overview of what that is, but could you go into a little bit more detail, a little bit about the process? So, and how long does it take? What do I need to provide? Who can, if you are a busy person running a business, how do I, like you said, I got to get my parents to confess to hopefully leaving me behind, not spending all of my inheritance, and I need to consider my daughter, and I've got all those things. So what are we does this process realistically look like?
It starts with data. Data for me is critical, and we've developed software to capture that data in a specific way. So it's not just the data, but it's also putting the data in the right boxes. So we've almost absorbed the complexity to say, all right, so how do we make this simpler? And it starts with understanding what you've got, where it is, and in which silo it is. The software helps us to do that, helps us to ask the right questions. So that is the starting point. The next is just understanding this family. And again, the software helps us just to get a generational view of the family. So is the grandparent still alive? Where are you currently in your state of life? There's a difference between, let's say, a 24, 25-year-old. I often speak to the younger generation that's got young kids, and I say, well, do you have an estate plan? And they say, well, no, they're still thinking about it. And say, you know what? I've got lots of gray hair. I've survived my risks to a great extent. You are looking after two young souls, and it's your responsibility to do that. And it is just massively irresponsible not to think of how those kids will be looked after if something happens to you. And I know young people are immune to death, but this is what we see. We are seeing that. We are seeing that it's young children that's not catered for. Those assets should go into trust. For a young person, it should go into trust. There's no other way. There's no other plan. And that is complex. So if you're a young person, I'm sorry, but you have got a complex life. Number one, you have to survive your risks. You have to survive your intimate relationships. We've got a massively high divorce rate in this country. And hiding away from the complexity doesn't help. You have to face up to it. But that is then the process in saying, all right, once you've got the data and once we understand the family, then only can you do the will. The will is the easiest part of the process. That is why the industry so glibly just pushes the will drafting in front, because it is cheating complexity. It's easy. Just sign this will and we'll sort it out afterwards. It doesn't work that way. So the answer to that question is, it starts with data. Somebody needs to know where everything is. It needs to be plotted. It needs to be plotted in the right place. Then you need to have a conversation with a correctly qualified professional to take you through this Pandora's box and to guide you through it. And 9 times out of 10, you do find a simple answer, and a simple will is the answer in many instances. But you cannot do a simple will if you haven't done the data gathering and knowing where what is. And that changes all the time. So my estate plan today and my estate plan in 5 years' time, and the younger we are, the quicker things change. All right, the older we are, the more it stays the same. So there is a huge responsibility on young people to make sure that their affairs is done. Not just doing a will, thinking about the succession?
Absolutely. Okay, so just a few questions coming in from our audience. Can one remove a beneficiary from a trust? The beneficiary is an adult.
You can. You need to be very cautious. So legally, you need to look at the trust deed and see what the trust deed says with regards to changing beneficiaries. So with trust, your starting point is always the trust deed, right? As a trustee, the question you need to ask is, if you are party to the removal of a beneficiary, what is the reason thereof? So trustees are meant to be impartial relative to the beneficiaries of a trust. And usually that impartiality is challenged when a beneficiary is removed without good reason. So we often remove beneficiaries, for instance, where they become citizens or green card holders in the United States of America, simply because very simple tax reasons. Same with Australia. People moving to Australia or to America, it is really important that they be removed as beneficiaries. But obviously, they need to get their fair share in another way. And there's a bit of gymnastics that we have to do with regards to that. But the answer is yes, it is possible to remove a beneficiary. The second is, it is very dangerous to do for the trustees. If a beneficiary that is removed without good reason approaches court to have the trustees dismissed, because that is the remedy that a beneficiary that feels that they've been hard done by can do, is they can actually have the trustees removed. So very, very careful. There is a big difference between trust assets and your own assets. There should be a clear dividing line in the way in which that is managed, and be very, very careful of this perception of fairness. Litigation between family members are driven by perceptions of fairness.
Yes, I have first-hand experience of that. I just wanted to sort of jump back a second. You mentioned, if there's beneficiaries, if trustees are from other countries, and et cetera, et cetera. So as South Africans, we have a mix of, and I speak for myself, but I hope that there are other people on this group that probably have a similar situation. We have a mixed sort of sources of beneficiaries. So, for example, I might have an inheritance that's offshore through my parents. I have a localized business. I have children who are dependent on me. So, I'm a South African citizen, but might hold dual citizenship between South Africa and the UK. Or another country. So, but I'm South African citizen and I have South African residency. So it starts to sound quite complicated. And I'm sure there's been a number of questions about, the implications of having dual residency or dual citizenship, living abroad, offshore investments. Can you enlighten us a little bit about how you deal with these processes in your stress test?
So your first question is, where are you domiciled? That usually is the critical question. The citizenship is really a secondary question, except for two countries. Now I'll come to them now. Most countries in the world tax you based on your domicile. So domicile is the place that you consider to be your personal place of abode. And there's a few tests for that. Where do you hang your art? Where does kids go to school, etc., etc. So in most instances, you've got your primary domicile in South Africa, but you might have assets that reside in other countries. Your South African executor can only manage those assets that is under his authority. And because the executor is appointed in terms of South African legislation, your South African executor only has got authority over assets that is in the Republic or in countries that accept the executor's authority, like, for instance, Switzerland. So if you've got assets in Switzerland, they will generally follow the directives of the executor on what needs to happen with the assets. So if you are an American or you are an American green card holder, Americans are taxed on their worldwide income, just like South Africans, but based on their nationality. All right, so two countries in the world. One is America. That's why we are so careful about American citizenship, green card holders, etc. It makes things more difficult. But for the rest, the passport you hold is moot. Certain assets in certain countries needs to have a probate process in that country. So if you, for instance, have got assets in the United Kingdom, everywhere where you've got assets, probate needs to happen. And the probate doesn't mean that you have to have separate wills. It means that a person must be appointed in that jurisdiction in terms of their laws to give effect to your last will and testament. So now you can see every country that you've got assets in, you introduce a potential probate process. And not only that, some countries, especially UK and the US, also levy an estate tax on the assets found in their jurisdiction, and the estate taxes there is higher. You would be surprised to know that in America, the estate taxes is up to 45%, where in South Africa it's 20%. So between 20 and 25%. So our estate duty regime is still fairly fairly soft from a tax point of view, but you can easily find yourself having to pay estate duty in a country that you've never visited, simply because you hold Apple shares on an American bourse. So yeah, it is complex. I don't think, Louise, it's difficult. I think it's complex, and the way to deal with complex solutions is actually to go and sit down and map it out.
If I can jump in here quickly,
sorry,
apologies, but it's probably worth elaborating just for 20 seconds on situs tax, which is what Louis just mentioned. So in essence, if an asset is on site in another country, on site could be a bank account, could be a property, could be, as Louis mentioned, shares. You know, if the company is incorporated in the US or has a share register in the US, those are situs assets. And when you pass away, that country has first taxing rights. The UK, 40% estate or inheritance tax. US, Louis mentioned, up to 45%. Now, the US, as an example, the threshold above which that kicks in is $60,000. So anything above $60,000 is taxed at 40 to 45% in the US. Clients have no idea. You know, we've got clients holding, you know, material amounts of Microsoft, Apple, Google, Amazon, all the wonderful shares that we love holding, and they don't realize that they're going to pay this massive tax when they pass away. In addition, you cannot roll that over to the surviving spouse. So that tax is levied when the first spouse passes away. In the UK, that threshold is higher. It's £325,000. And in most circumstances, you can actually roll that over to the surviving spouse. So when the surviving spouse passes away, anything above £650,000 will get taxed at 40%. Now, that doesn't necessarily mean you're going to pay inheritance tax in the UK or the US plus South Africa. You get a credit, and there's double taxation agreements. But where there are countries, some countries in Europe, for example, don't have these double taxation agreements, you could pay tax twice. So it gets very complicated, it gets very intricate, especially when you go cross-border. And that's why we always say, you know, yeah, you do need to speak to specialists that understand this world. We understand this world, which is a good thing. We've got only a few minutes left, and I do want to get to some questions. Can we start at the bottom and just move up a little bit?
Yeah,
question. Yeah.
Yes, go ahead. Go ahead.
Okay, thanks. There's one question. I know the person, and I know that he wants an answer to this question, so I'm going to pose it. So Michael sent a question. If I can summarize it, it's for you, Louis. If you're a beneficiary of a trust, how do you ensure that your kids are going to get that asset that's sitting in the trust one day? Can you bequeath it to them? Can you? How you know? Is there something that you can do?
All right. So the quick answer there is it's got nothing to do with your will, because it's a trust asset that sit in that silo. The Achilles heel of trust is trustees. Okay, so you need to make absolutely sure that you're in control of who is your succeeding trustees. And one of the things that you need to do in your planning, especially when you've got a trust, is you just take that letter of authority that the master issued you and take out your name and your spouse's name and see who's left, and see if you're comfortable with how they are going to manage the assets. So that is that third law of the process: get kids involved. Get your kids involved at the age of 30 if possible. Have the control within the family of that trust. That is the best way to ensure that your beneficiary will eventually get the assets. All right. Careful of captured trust. Captured trust is what I call a trust that is run by corporate entities, etc. It's officials in corporate entities that manages the trust. If they are in control, just be very, very careful. There's very good entities out there, but even in our own practice, I advise clients to make me a minority. All right, so that is how serious I feel about making sure that the family and people that you know controls the decision making in that trust, and that is the only answer I can give you. It is uncomfortable, but that is the nature of the beast.
Okay, Debbie's question we've answered.
Did you see Alex's follow-up question was, saying about if 70% of the children, sorry, I'm just trying to follow.
Can we then apportion percentage,
yes,
i.e. 70% to minors and balance to adults? So I think Louis pretty much answered that. It's very tricky to do. I guess that those kids need to be beneficiaries at the end of the day. Yeah, Louis, do you want to add to that?
It's a good question because, and I'm going to give you, there's no hard and fast rules because trusts are discretionary, so trustees can basically, within reason, do what they want. Our guideline there is always to follow the normal succession rules. So if you've got 3 kids, it's split into 3, and then that kid's third gets split depending on how many children they've got. And this is where the perception of fairness comes in, because I might have 3 children. One has got 1 kid, one has got 2 kids, and the other one's got 3 kids. All right. So there's the benefits of the 3 is going to be different on the grandchildren level, because there's more children to one parent. So instead of one getting all, one gets a third. That's natural. It happens. My advice is do not mess with that. You create massive problems, you know. So just stick to that, then it works.
Okay, another question, Louisa. I want to answer this one. How much does the MyLnD program cost? So the cost is 15,000 Rand, 15. That includes 2 bespoke wills, drafted by the likes of Louis, so admitted attorneys. And if I can compare that to the value that's added, it's really not a material amount. And the work that I know that goes into it, and the analysis and years of experience. So maybe just quickly, I'll run through some clients of mine that have gone through the process and basic areas we found. 2 of my clients thought they were married in community or property. They actually married out of community or property because they got married in the UK. I mean, that's absolutely fundamental to estate planning, you know, what regime you married in. Another client of mine, I went through the process and found out that his ex-wife who cheated on him is still a beneficiary of his trust with all of his assets. I had to break that news to him with the family it was on a Zoom call. You can understand that wasn't a pleasant conversation to have. Another client of mine owns a company in a trust, significant company, significant trust, and it turns out that the trust hasn't submitted tax or financials in 6 years. So this MyLnD identifies problems, it identifies errors in planning, it identifies remedies to sort things out, and also we go through opportunities to use structures to reduce your tax, to make sure that everything works, that the will does work as you plan, etc. And then on death, what happened, right? Louis said you wind it up in 6 months on average, so the family gets closure much sooner. Because it takes us 6 months, We don't have to spend years winding it up. We can be very flexible on the executive fees. So it is one of those products that, you know, when you speak to clients, they sort of say, well, shouldn't this be like the first step in any financial plan? And the answer is yes. But as Louis said, the industry doesn't do it because, you know, there's no immediate sort of, you know, people are focused on what assets do you get and how do I manage those assets, as opposed to doing the holistic financial planning. So long story to say, 15,000 Rand is actually not a lot of money when you look at the benefits.
Thank you so much, Anthony. Thank you so much, Louis. So we have got all of the questions that have come in, and I will share it with the team and they can answer them through email. We've now reached the end of our time, and I know that many people have busy days. So I thank you to everybody who's attended this webinar today. I hope that you found the information useful. For those who agreed, we will share your details with the team so that you can look at the way forward. I think as I'm sure you now realize, this is a much needed solution. You know, it's almost how most things are planned. You've got to look at the end goal and work your way backwards to get the right plan in process. So I hope that you enjoyed it, and I look forward to having another discussion with the Carrick Consult team. And if you don't mind playing the video, thank you very much to everyone that joined us, and we look forward to seeing you again soon.